Yes, the I word, impeachment. Since Clarence Thomas has so far chosen not to resign, not to do a fortis, why aren't more Democrats joining AOC and calling for his impeachment? Because from my perspective, there is a strong case for impeaching him. In fact, in my view, there are three main reasons why Justice Thomas should be impeached, and that's what we're going to examine today. First off, number one, the financial case for impeaching Thomas. As I mentioned, explosive new reporting from ProPublica has revealed the justice's undisclosed dealings with GOP mega-donor businessman Harlan Crow. The same Harlan Crow, incidentally, who it turns out owns an autographed copy of Mein Kampf and a collection of Nazi linens in his library, according to the Dallas Morning News. He says he's just preserving history, as you do. But I digress. According to ProPublica, Clarence Thomas has vacationed with Crow almost every year for 20-plus years, travelling on Crow's private jet, hobnobbing on Crow's super yacht, and spending time at Crow's private resort in upstate New York. On one 2019 vacation to Indonesia is estimated by ProPublica to have been worth around $500,000, to give you an idea of the alleged value-changing hands here. According to ProPublica, the extent and frequency of Crow's apparent gifts to Thomas have no known precedent in the modern history of the U.S. Supreme Court. I wonder what the late Abe Fortas would have made of all this. By the way, these lavish romps are certainly different than the vacations Thomas professed to enjoy in the 2020 Harlan Crow-funded documentary about Thomas's life.
You know, I don't have any problem with going to Europe, but I prefer the United States. And I prefer seeing the regular parts of the United States. I prefer going across the rural areas. I prefer the RV parks. I prefer the Walmart parking lots to the beaches and things like that. There's something normal to me about it. I come from regular stock, and I prefer that. I prefer being around that. Spoiler alert, that is not a Walmart parking lot. What's worse, sorry, I'm still laughing about that clip. I'm a regular kind of guy. What's worse, these lavish trips with Crow were not included on Thomas's financial disclosures. Supreme Court justices and other federal judges are required by law to disclose gifts they've received, though there are some exceptions for what's called personal hospitality. Of course, that's just what Justice Thomas cited in a statement released last week. Justice Thomas says he was advised that this sort of personal hospitality from close personal friends who did not have business before the court was not reportable. He also says now that the guidance has been updated. He'll follow this guidance in the future. But I'm calling BS. Really, Justice Thomas, you needed it spelled out for you that it's inappropriate for a supposedly impartial public servant, for a top judge, to take extravagant trips with a Republican mega-donor. And here's the thing, there is a strong case that the personal hospitality exception does not apply to Thomas here. ProPublica reports that Thomas would often meet with major Republican donors, business executives, and even Federalist Society leaders at Crow's mountain retreat. The American Prospect argues this amounts to government business and not personal hospitality, making Thomas's failure to disclose these gifts a direct violation of the post-Watergate Ethics in Government Act. And if you look at how the rules define personal hospitality, they describe it as, quote, hospitality extended for a non-business purpose at the personal residence of that person or facilities owned by that person or family. And as Dahlia Lithwick and Mark Joseph Stone note in their piece on this issue for Slate, quote, a person dead set on defending Thomas might be able to squeeze these yacht trips into this definition, arguing that by hosting Thomas on his boat for food, drink and sightseeing, Crow extended hospitality on his own property. But lending out the private jet for Thomas's personal use? Come on. Letting somebody use your private jet to travel around the country is not extending hospitality on your property. It is lending out your property to someone else so they can avoid paying for a commercial flight. What's more, Crow's status as a close friend of Thomas is questionable. As Indiana University professor Charles Jay pointed out to NBC News, Thomas and Crow were not childhood friends. They met when Thomas was on the Supreme Court, when the justice had to understand that Crow's interest in bringing Thomas into the fold of friends who enjoyed such lavish treatment was attributable, to his status as a judge. Not to mention the fact that Crow gave $500,000 to the justice's now infamous wife Ginny's right-wing lobbying PAC, Liberty Central, back in 2009, according to Politico.
So again, this isn't some old personal family friend who was only interested in hanging out with Thomas over the summer. Come on. This is someone who befriended Justice Thomas and certainly has an interest in influencing a powerful conservative justice on a whole host of issues. Oh, and Crow's donations to Ginny's PAC in particular look uncomfortably close to an attempt to lobby Clarence. An obvious no-no. On that point, Crow did tell ProPublica the hospitality we've extended to the Thomases over the years is no different from the hospitality we've extended to our many other dear friends. We have never sought to influence Justice Thomas on any legal or political issue. But it doesn't end there. On Thursday, ProPublica dropped another bombshell report, this time revealing that Harlan Crow bought property from Clarence Thomas, including his mother's home, for over $133,000, according to state tax documents and a house deed from 2014. And again, Clarence Thomas did not disclose this. Crow told ProPublica he purchased Thomas's mother's home to one day turn it into a museum. Thomas did not respond to ProPublica. But wait, there's more. This relationship with Harlan Crow isn't Justice Thomas's only financial scandal. No, it's just a mouldy cheese on top of his financial impropriety pizza. Let's not forget the New Yorker report on one of Ginny's other brushes with lobby, including her undisclosed paid consulting work for the Center for Security Policy founded by far-right activist Frank Gaffney. Gaffney submitted an amicus brief to the Supreme Court in 2017 in support of the Trump administration's Muslim travel ban, while Ginny was on their payroll. Not only did Justice Clarence Thomas fail to recuse himself from that case, he actually voted in favor of the Trump ban, surprise, but he also didn't declare the $200,000 his wife earned in 2017 and 2018 from Gaffney's group, which judges are supposed to do. So that is the financial case for impeaching Thomas, the lavish undisclosed gifts, the wife's paid undisclosed lobbying, the likely violation of the law.